चलो बहुत बहुत धन्यवाद, तुमने हमें हमारा कोड की तारीफ की। हम तुमको बिस्कॉफ खिलाएंगे, लो बिस्कॉफ का। बट बिस्कॉफ तो एक ही है, नेक्स्ट टाइम बिस्कॉफ जो पहले। चलो बहुत बहुत धन्यवाद, आपने कोड की तारीफ की। We have to start Indian judiciary today. I can see mix of students. आपने इंडियन जुडिशरी आईजीपी सेक्शन में पहले पढ़ा होगा, है ना? Anybody who has already studied Indian judiciary in the IGP section before? For you there can be some repetition, okay, but here will be more factual and here will be covering more of those topics जो कि हमने वहाँ पे cover नहीं किया, जैसे tribunals and all we did not cover there क्योंकि वो requirement नहीं था in optional. So here we will be talking about the appointment structure and then the quasi judicial bodies will be talking. Write the name of this chapter. Indian Judiciary. Indian Judiciary. Now here write those pointers in the syllabus which we are going to touch, okay. So first write separation of power, and dispute redressal mechanisms. Then structure, organization, and functioning of the judiciary. And next, quasi judicial bodies. Right, introduction. Right. The concern of justice. Has been one of the primary concerns of any political system. एक कोट लिखो, the seat of justice is the seat of God. The seat of justice is the seat of God. This is the statement from Mahavir Tyagi, Constituent Assembly member. Mahavir Tyagi, Constituent Assembly member. ठीक है. Now we know that the doctrine of separation of power says that state is standing on three pillars. There are three organs of the state. We have the legislature, we have executive, and we have the judiciary. And these state and the organs, they are emerging from the constitution, right? And constitution, we know, is emerging from the will of the people, because the constitution, the very first phase, says that we the people of India. So it is emerging from the will of the people. Now, why this mechanism has been created? So that the three organs, they will not only divide the power amongst each other, they will separate the power, rather they will also keep each other accountable. For example, legislature's primary role is to make law. Executives, they are taking any executive action, that means they are implementing the law. And the judiciary, its responsibility is to see that whether this action is as per the law or this is the prime function of the judiciary. देखा जाए तो ये तीनों organs, legislature, executive and judiciary, they are co-equals. But judiciary has got a special responsibility of ensuring that all the three organs, that means legislature, executive and judiciary itself, should work within the limits of the constitution. It should not cross that particular limit. That means judiciary is like the class monitor. That means जो class representative होता है वो भी तो है तो एक student, but he has been given an extra responsibility by the school administration that he will make sure that everybody is following the discipline. But that does not mean that he himself will not follow it. आपने देखा होगा वो क्लास मॉनिटर को रिस्पॉन्सिबिलिटी मिलती थी कि सबके नेल्स चेक करना, रूल पॉलिश ठीक ठाक है कि, बट दैट डज नॉट मीन कि वो खुद नहीं करेगा, खुद भी करना पड़ेगा. So the extra responsibility that judiciary has, that the judiciary has to ensure that everybody is following the constitution. And therefore, when any action is being taken by the executive, judiciary has the power to review that particular action. It will review it. Now, when it will review it, it will have to keep something as a parameter. किसी न किसी पैरामीटर पे तो जज करेगा ना कि ये एक्शन सही है या नहीं है. And that parameter will be the law made by the legislature. The law made by the legislature. But we know that if we consider this as the ultimate truth, कोई जरूरी तो है नहीं, लॉ भी गलत हो सकता है. So what if the law is not correct? That means if the judiciary has to review this particular law, again it will need certain parameter to compare कि क्या सही है क्या गलत है, and that parameter will be the constitution, that whether this law is as per the constitution or not. But we also know that in India, legislature has been given power under Article 368 to amend the constitution. Amend the constitution. अब जैसे एक imaginary situation imagine करो कि there's a law which says that anybody who is speaking against government, या फिर मान के चलो पुलिस ने क्या किया, somebody was speaking against government, police arrested that particular person. Now this is the action by the executive. When the matter will come to the judiciary, judiciary will review this action. The police will say that there's already a law which is saying that anybody who is criticizing government should be arrested. In that case, what will the judiciary do? The judiciary will see that this law is wrong. Why? Because the constitution is not giving any such power. Then what the legislature may do, that it will amend the constitution itself. और constitution में एक जगह लिख दिया जाएगा that anybody who is under article 21 में एक let us say exception बना के लिख दिया गया कि if somebody is criticizing government, then he can be arrested. Now, in that case, what the judiciary will do? In that case, the judiciary will refer to something called as the basic structure. And the basic structure in a country like India, where we have democracy, cannot say that you should be arrested for criticizing the government. So basically, this entire mechanism has been created just to make sure that the government, the state, is a limited state. It is a limited state, जिसको हम constitutionalism कहते हैं. Limited state is constitution. But when we look in a parliamentary form of government, in a parliamentary form of government, again, the three organs of the state, legislature, executive, and judiciary. In parliamentary form of government, what happens is that executive has the confidence of the legislature. That means only when they have majority in the legislature, they can form executive. So in a way, executive controls legislature. यदि आज के टाइम में हम कहें कि government wants to pass a bill, ordinary bill, बिल्कुल पास करा देगी. They have the majority. If the government want to pass an amendment also, then they have the special majority. They can pass that particular amendment. That means in the parliamentary form of government, executive is already controlling the legislature. And executive के power पे legislature is not a control. If today Prime Minister wants to bring any law, if Prime Minister wants, most probably Council of Ministers will say yes to that. If Council of Ministers say yes to that, then the legislature will also, majority तो बनी जाएगी ना, मे बी opposition में कुछ लोग होंगे जो कि minority जो नहीं support करें, but law तो pass हो जाएगी. So for an executive, legislature actually cannot make sure separation of power. Then the only challenge remains is the judiciary. Because the constitution at one hand gives power to the legislature to make law and to amend the constitution, but it gives power to the judiciary to review this law. We have one article called Article 30. And the judiciary has derived for itself the power to review this constitutional amendment through basic structure. Basic structure. यानी गवर्नमेंट के तीन ही एक्शन हो सकते हैं, एग्जीक्यूटिव एक्शन, लेजिस्लेटिव एक्शन, वो दोनों रिव्यू हो सकता है आर्टिकल 13 के थ्रू. एंड थर्ड, हाईएस्ट एक्शन क्या हो सकता है, कॉन्स्टिट्यूशनल अमेंडमेंट, दैट कैन बी रिव्यूड थ्रू द बेसिक स्ट्रक्चर डॉक्ट्रिन. So it means कि for executive problem is not this, problem is judicial, and therefore we have seen that governments will try to control the judiciary. अब judiciary को control करने का जो तरीका है वो primarily it can be through two ways, appointment and removal process. Because जो expenditure है सुप्रीम कोर्ट का, that is already a charged expenditure, उस पे voting नहीं हो सकती. So two ways in which judiciary can be controlled is appointment and removal. We will see today that removal is already in the hands of legislature. Removal is already in the hands of legislature, or legislature executive control कर रही. Now the only thing which remains is appointment mechanism, that how appointment can be done. If appointment can be controlled, then executive can ensure that judiciary is largely under the control of the government. And that's why there has been a debate on the appointment mechanism, कि कैसे judges को appoint किया जाए. If we look into the evolution of the process, initially it was under the control of government, and then the collegium system developed. We'll see the evolution of the collegium system, and currently we cannot say that it is completely under the control of government, and it is not also completely under the control of judiciary. It is a shared mechanism that they both are sharing with. That means currently it is the judges who will recommend the name, and it is appointed by, a judge is appointed by the president. So we have seen that while at one hand judges are recommending the name, collegium system is recommending the name, but government appoints only those whom they are comfortable with, but it maintains that particular balance. अब एक heading लिख दो, appointment of judges. Appointment of judges. Now, when we talk about the appointment of judges, across the world you will find that there are broadly two types of mechanism. One is what we call as inter-institutional mechanism we have. The second mechanism is the appointment commission method, judicial appointment commission method. Now, the inter-institutional approach is when two organs of the government, they are coming together for appointment. It can be legislature along with executive, or it can be executive along with the judiciary. That means two organs of the state, they are coming together for the appointment mechanism. For example, in US you will follow this particular method. In US what happens is that the president appoints, executive is appointing, and the Senate, which is part of the legislature, will approve of that particular name, and it is for all level of judges. जो US federal judicial structure है, there you have the Supreme Court, you have the Court for Appeals, and you have the District Court. और तीनों level पे it is the president only who is appointing, and it is the Senate which is approving the name. So basically it is the legislature along with executive who are making this appointment. But in countries like India, the mechanism is that executive, president will appoint after consultation from the judiciary, जिसको हम collegium system कहते हैं. ठीक है? And there are yet another method, for example, which is followed in UK, when you have appointment commission. जैसे एक IAS को appoint करने के लिए UPSC, Union Public Service Commission. Similarly, at the state level, we have state public service commissions. Similarly, for the judges also we can have a commission, जहाँ पे there will be some set of people from judiciary, from advocates, मतलब both judges and advocates, from civil society, from legislature, from executives, and they will make such kind of appointments. These are the broadly the way in which the appointments are done of the judges. In India, we have Article 124, which talks about the appointment. It says that when it comes to the Supreme Court, the president will make the appointment after consultation of such number of judges from Supreme Court and High Court. वो president पे कि वो किसको consult करता है. ठीक है? And this has resulted into the present system in which 5 judges, that is the collegium system, that has emerged. तो इसको पहले लिखेंगे introduction, right? Right. Across the world, judges are appointed through following methods. Is my first point, right? interinstitutional approach in this first subpoint, right? Legislative executive model. Legislative executive model. In this, right? The executive appoints after the approval of the legislative body. For example, in US, the president nominates a candidate which requires confirmation by the Senate. Second subpoint, right? Judiciary executive model. It includes appointment by the executive after consultation from the judiciary. For example, in India, the president appoints Supreme Court judges after consultation with the judges from the Supreme Court and the High Courts as the President may consider necessary. प्रेसिडेंट तो एग्जीक्यूटिव का हेड भी है, तो प्रेसिडेंट तो लेजिस्लेचर का पार्ट है डेफिनेटली. इवन जब वो साइन करता है तभी वो लॉ बनता है, बट ही इज ऑल्सो द हेड ऑफ द एग्जीक्यूटिव. ऑल एग्जीक्यूटिव डिसीजन ऑफ द यूनियन इज टेकन इन द नेम ऑफ प्रेसिडेंट ओनली, सो इज पार्ट ऑफ एग्जीक्यूटिव. ठीक, इसी में लिखेंगे. इसमें ब्रैकेट में लिख दो आर्टिकल 124 क्लॉज 2. पहले नॉमिनेट करता है प्रेसिडेंट, उसके बाद सीनेट उस पर अपना डिसीजन लेते हैं. ठीक, इन ब्रैकेट राइट आर्टिकल 124 क्लॉज 2, ये जो अभी लिखा ना उसको. ठीक, इसी में नेक्स्ट पैराग्राफ राइट. सिमिलरली as per Article 217, as per Article 217, a judge of a high court is appointed by the President in consultation with the Chief Justice of India, the Governor of the state, and the Chief Justice of the High Court. ठीक है, अभी इसको आगे हम देखेंगे फिलहाल. Now write the second, Judicial Appointment Commission Method. ये पहला हमने लिखा इंटर इंस्टीट्यूशनल. सेकेंड मेन पॉइंट, जुडिशियल अपॉइंटमेंट कमीशन मेथड, JAC. Right. In countries like England, South Africa, Malaysia, judicial appointments are made by commissions having members from legislature, judiciary, executive, and even civil society. For example, the Judicial Appointment Commission of England have 15 members, इसमें डैश देख लेंगे. 3 are judges, and 12 members are recruited through open competition. नहीं, it can be exam, it can be any kind of, मतलब जैसे कोई जरूरी तो है, ये UPSC कुछ लोगों को lateral entry से लेती है कोई एग्जाम में, मतलब ये ओपन कंपटीशन है. एनी यू विल हैव टू अप्लाई फॉर दैट एंड यू कैन बी द पार्ट ऑफ दैट जुडिशियल अपॉइंटमेंट कमीशन. नाउ गिव अ हेडिंग, डिबेट ऑन द अपॉइंटमेंट प्रोसेस. हाँ, what is lateral entry? Lateral entry basically means when you are entering into the administration not through the proper exam process. जैसे UPSC अभी एक एग्जाम लेती है. If you want to become IAS, then one option is that you will give UPSC exam. You will enter into the service, UPSC qualify करके SDM, DM, secretary तक पहुंचेंगे. The second is that you don't follow this normal process, rather on the basis of your experience, ठीक है, you may be appointed at any of the key positions. जैसे RBI governor, you'll see sometime there will be an IAS officer will be RBI governor. Raghuram Rajan was also RBI governor, but he was not a IAS. Okay. Similarly, there can be various positions. In fact, for the position of ambassadors also, there will be foreign service officers, and there can be some people who are not from bureaucracy. They can be from the field of law, journalism, politics, and they can also be sent as India's ambassador. For example, there was one lawyer, Nani Palkiwala. Okay. He was sent as India's ambassador to US when Janata Party government came to power. So these are all lateral entries. That means you're not coming through a proper exam, rather you are coming at the later stage on the basis of your experience. Of course, it will be, many of it will be through UPSC, or it can be without UPSC also. सिविल सोसाइटी को इसलिए इंक्लूड किया गया बिकॉज सिविल सोसाइटी इज वन ऑफ द पिलर्स फॉर डेमोक्रेसी. आप देखोगे अथॉरिटेरियन गवर्नमेंट्स है, दे डोंट गिव मच इंपॉर्टेंस टू सिविल सोसाइटी, वो अपना डिसीजन लेंगे. सिविल सोसाइटी को इसलिए इंक्लूड किया गया क्योंकि दे आर, एक तो हो गया गवर्नमेंट, एंड गवर्नमेंट इज मेकिंग द पॉलिसी, एंड सिविल सोसाइटी इज दैट ग्रुप जिसको कि कंसल्टेशन देना चाहिए फॉर मेकिंग दैट पर्टिकुलर who is ultimately being affected by judicial decisions, the civil society. इसलिए इसको एक पिलर बताए. ठीक है. कॉन्स्टिट्यूशनल सुप्रीमेसी कहा जाएगा. मतलब इफ एट ऑल यू वांट टू चूज बिटवीन, देन एक तरह से देखा जाए तो सुप्रीमेसी तो किसी की नहीं है, बैलेंस है. ठीक है. बिकॉज कॉन्स्टिट्यूशनल सुप्रीमेसी भी इसलिए नहीं कह सकते कि ऐसा नहीं है कि कॉन्स्टिट्यूशन को अमेंड नहीं किया जा सकता, किया जा सकता है और ठीक ठाक आसानी से किया जा सकता है. इट्स नॉट एज टफ एज यूएस. आप यूएस का एग्जांपल लोगे तो इन यूएस कॉन्स्टिट्यूशन हैज बीन अमेंडेड टिल नाउ ओनली 27 टाइम्स, इजंट इट? सो बेसिकली जिसमें कि 10 अमेंडमेंट पहले 4 साल में ही हो गए थे. लास्ट अमेंडमेंट वाज डन इन यूएसए एट द स्टार्ट ऑफ 90s. सो बट इन इंडिया वी हैव अमेंडेड इट ऑलरेडी मोर देन 100 टाइम्स. 106 अमेंडमेंट हो गया. जुडिशियल सुप्रीमेसी के साथ बैलेंस इसलिए है बिकॉज एनी अमेंडमेंट दैट यू डू इज एक्चुअली बीन रिव्यूड बाय द जुडिशरी. बैलेंस कहा जा सकता है. ठीक है, आगे बढ़ते हैं. There can be various factors. There can be legacy factor. For example, why India went for interinstitutional mechanism, because if you see the Constituent Assembly debate, there were certain members, since the Constituent Assembly in India, it was full of lawyers, people from the law background. So they wanted that the appointment mechanism should be completely under the control of judiciary. But there were certain members who said that if you provide this, then judiciary will become imperium in imperio. That means it will become a separate state, accountability ही नहीं रहेगी. And therefore interinstitutional mechanism was selected. तो कुछ भी हो सकता है. India also tried for the judicial appointment method. हम देखेंगे. ठीक है, आगे बढ़े. Right, debates on the appointment system. Now, as I said that in the Constituent Assembly, there was one group which was saying that judiciary should be completely independent of any other organ. यानी जजेस का अपॉइंटमेंट कौन करे? जजेस ही करे. इवन प्रेसिडेंट को नाम भी नहीं जाना चाहिए, सीधे चीफ जस्टिस ऑफ इंडिया देखे कि किसको अपॉइंट करना है एज अ नेक्स्ट जज, एंड ही शुड बी अपॉइंटेड. बट देयर वर अदर ग्रुप, they wanted more control of legislature or executive on this, because they believed कि यदि ऐसा करते हैं then judiciary will become very very powerful. And remember that in a democracy, which organ of the state is the most legitimate? किसको legitimate सबसे माना जाए? Legislature, because they are the people who are being elected by the people of India. Judges may be very much educated, wisdom, but they are not having the legitimacy emerging from the elections. Parliamentarians, we can question about the quality of legislation, quality of debate, quality of the MPs, but ultimately they reflect our preferences. So therefore, the most legitimate organ is the legislature, and there should be some control in that particular manner, and we settle for the interinstitutional approach. Now, from the starting time, you will see that starting 1950 till 1973. 1973 is an important year because here we are seeing the Keshwanand Bharati case. From 1950 to 1973, we saw that the appointment of the Chief Justice of India used to be very simple. Whosoever is the most senior most judge, unko Chief Justice of India bana diya jata. There was one exception when one senior most judge was not made the Chief Justice because he was medically not fit for it. Otherwise, it was a rule that whosoever is the senior most judge, usko Chief Justice bana diya jayega. But it was for the first time in 1973, after the Keshwanand Bharati case, we saw that judges were superseded. It was a 13-judge bench, and the decision was from 7:6 majority. That means the 7 judges, they were against the government. Against the government means they were saying that government legislature cannot amend the constitution the way they want. They wanted limited power of amendment. And 6 judges were in favor of government. This was the combination. After this verdict, this verdict was given on 24th April 1973, which was the last working day of Justice S.N. Sikri. He was to retire, and the next Chief Justice of India should have been the next judge in seniority. But he was not made the next Chief Justice of India. Rather, it was Justice A.N. Ray, who was the senior most judge amongst those judges who had supported the government. तो ये जो 3 judges हैं, इनको supersede कर दिया गया, and he was made the next Chief Justice. Of course, these 3 judges, they resigned in protest. Of course, they will not be serving against a judge, below a judge who is otherwise junior, but he is the Chief Justice. So they resigned in protest. Similarly, there was another case, that was the ADM Jabalpur case. This was the case of 1976. इसमें भी 5 जजेस थे और फैसला जो था वो 4:1 का फैसला था. 4 judges in favor of government, 1 judge, Justice H.R. Khanna, against the government. And the next Chief Justice of India was supposed to be Justice H.R. Khanna as per seniority, but he was superseded, and Justice M.H. Beg, who supported the government in this case and who had supported the government even in the Keshwanand Bharati case, was made the next Chief Justice of India. So we witness that how government is selecting Chief Justices on the basis of its political convenience, कि वो judges जो government की philosophy से align कर रहे हैं, उनको Chief Justice बना दिया जा रहा है. So it is happening in 1973, it is happening in 1976. And then this important question came before the Supreme Court for interpretation. And that important question was that when ये जो 3 judges case है, the first judge's case, second judge's case, third judge's case. Now in S.P. Gupta case of 1981, this is called the first judge's case of 1981. Now in this, Supreme Court was asked to interpret कि जो ये Article 124 Clause 2 है, which is talking about the appointment of Supreme Court judge, and जो आर्टिकल 217 क्लॉज 1 है, which is talking about the appointment of High Court judge. इसमें ये लिखा हुआ है कि the president, this says that president shall appoint a Supreme Court judge after consultation from other judges of the Supreme Court or the High Court. And similarly here it has been said that president will appoint the High Court judge after consultation from Chief Justice of India, Governor of the state, and the Chief Justice of that particular High Court. Now this consultation which these judges will give to the president, is this consultation binding on the president? मतलब कि president asks for the name and the judges, they have given 10 names to be appointed. Can we say that president is bound to appoint these judges or ये पूछा गया. So basically the question is that can we say that consultation is also concurrence? आपको आप यदि president is asking for the suggestion, will it be binding or not? This was asked from the Supreme. 1981 Supreme Court said, it was a 7-judge bench, and Supreme Court said that this suggestion is not binding. This suggestion is not binding. That means नाम suggest किया जाएगा. If president wants, he can appoint. If president does not want, he will not appoint. So this suggestion is not binding. The same question came before the Supreme Court again in 1993, what we call as the second judge's case or Supreme Court Advocate on Record case, 1993. फिर से ये पूछा गया कि under Article 124 and 217, when the suggestion is being given, is it binding? In this case, the Supreme Court said, it was a 9-judge bench, and the Supreme Court said, yes, the suggestion is binding. President को मानना पड़ेगा. But the only difference is that this opinion will not be the opinion of one single judge, just Chief Justice of India. Rather, it will be a group of 3 judges, one Chief Justice of India and 2 senior most judges, जिसको की collegium कहा. This is judgment of 1990. Again, this matter is coming in 1998, and this was through the presidential reference. किस article के through होता है? Article 143. The president asked, it was the Atal Bihari Vajpayee government, and president asked that, tell us for the final time कि क्या ये जो consultation जाता है, जो recommendation जाता है, is it binding on the president or not? And here Supreme Court again said that yes, it is binding on the president. The difference is that now they expanded the collegium from 3 judges to total of 5 judges, in which you will have 1 Chief Justice of India and 4 senior most judges. And this seniority will not be determined by the age of that particular judge. Rather, it will be determined by the time that he is in to the Supreme Court. जब से वो Supreme Court में काम करे, वो seniority लिया जाएगा. It will not be the age-wise seniority. And it was also mentioned that these 5 judges should include, the collegium should include the next Chief Justice of India. The collegium should include next Chief Justice of India. And it is the reason sometimes you will see that collegium becomes a 6-member body also. जैसे when Chief Justice D.Y. Chandrachud was there, then for some time it was a 6-member body. और ये 6-member body इसलिए थी because the Chief Justice of India D.Y. Chandrachud was there. Rest of the 4 senior most judges who were there, they were they would never become the next chief justice क्योंकि इनका tenure इतना लंबा था. So they would retire, and therefore Justice Sanjeev Khanna was also included in the collegium. That means there were total 6 judges. When one of them retired, that means now it became a 5-member body. So it is not mandatory that it will always be a 5-member body. So you can see the change in the response of the Supreme Court. In this case, the 7-judge bench is saying that whatever consultation the Chief Justice is giving to the President is not binding on the President. In this case, 9-judge bench overruled this decision and said that whatever consultation the judiciary gives to the President shall be binding on the President, and this recommendation will be of not one person, rather it will be a collegium of 3 judges, Chief Justice of India and 2 senior most judges. Again the same question in 1998, 9 judges bench. Here it was 9 judges bench, 7:2 majority. Here it was a 9-judge bench unanimously said that whatever consultation is going, it is binding on the President, and they expanded the collegium system from 3 to 5 judges. Now, why this change in the response is coming? 1981, जब हम देख रहे हैं again a very strong government, Indira Gandhi government is in place. Judiciary will be a passive judiciary. But when we come to 1993, we have entered into the era of coalition, and we are witnessing short-lived governments. In fact, 1989, Rajiv Gandhi completed his tenure. 1991, VP Singh became the next Prime Minister. Then Chandrasekhar became the Prime Minister within 2 years. Then PV Narasimha Rao became the Prime Minister. So it is the time when there is a political instability. The governments are very, very weak, and therefore the judiciary will see this opportunity to take the control of the appointment. मैंने बताया था कि the only challenge to the government's power is judiciary, and judiciary has 2 strings attached: appointment and removal. Removal is already in the control of legislature. Appointment एक ऐसा mechanism है जो कि judiciary चाहेगी कि अपने पास रखे. They don't want it to go to the executive, because when it was under the control of executive, we have already seen that how executive was misusing this power. We have seen how the chief justices, they were getting appointed. So this was settled, but nevertheless हम देखेंगे that 99th amendment was brought to get the National Judicial Appointment Commission. पहले इतना लिखेंगे, right? Senior most judges, most senior most judge. ये जो second judges case हुआ था, उसमें ये चीज भी clarify की गई that whosoever is the most senior most person, the person will become the chief justice. और चाहे वो 1 सप्ताह के लिए क्यों ना बने, but he will become the chief justice. ठीक है, चलो इसमें right first point. In the Constituent Assembly, it was proposed that judicial appointments should be completely under the control of judiciary, However, members like T.T. Krishnamachari, argued that this will make judiciary an imperium in imperio, in bracket, right? State within state. इसी में लिखेंगे A.K. Iyer, also argued that such provision will make judiciary as super legislature or super executive. Therefore, the Constituent Assembly went for interinstitutional mechanism. Second point, right? First judge's case. In bracket, right? S.P. Gupta versus Union of India. First judge's case, S.P. Gupta versus Union of India, 1981. The seven-judge bench ruled that the president was not bound by the advice of CJI. That is consultation does not mean concurrence. So यहाँ पे बेसिकली कोर्ट क्या है? कोर्ट इज गोइंग फॉर द टेक्सुअल इंटरप्रिटेशन, क्योंकि कंसल्टेशन शब्द का डिक्शनरी मीनिंग क्या है? दैट आई एम जस्ट टेकिंग व्हाट इज योर ओपिनियन, है ना, एडवाइस ले रहे हैं, ये बाइंडिंग थोड़ी है। आपके दोस्त ने कहा कि तुमको मूवी दिखाएं क्या आज, उसने तो कंसल्टेशन लिया सर, आपने कह दिया हाँ दिखाओ। आप थोड़ी बोल सकते तुमने बोला है तो बने, आप रिकमेंड कर सकते हैं, आप मना भी कर सकते हैं, आप यस भी कह सकते हैं, but it is not binding on him, isn't it? It is just consultation, simply means that I want to take a decision, I want your opinion on that. It is just the literal meaning. तो ये बहुत ही textual interpretation था. Political conditions भी 1981 में ऐसे ही थे, because in 1980 Indira Gandhi government again came to power, a strong government, it came to power in 1980. So in fact जो आप देखेंगे ना, ये जो टाइम था 1977, from 1977 to 1980, this is the time when the judiciary was active judiciary. ठीक है, इसके बाद भी रही, but mostly, in fact there have been many cases. There's one very famous case called the Menka Gandhi case, that is of 1978. That means जहाँ पे due process of law को accept किया गया. Then there's a case called Raghukul Tilak case, wherein it was said that governor is not an employment under Government of India. This is a judgment of 1979. There's a case called Hussain Ara Khatun case of 1979, which from where the public interest litigations came into existence. So 77 to 80, the judiciary is quite active, but 1981, it is going for textual interpretation, okay, which it is going to change in the later cases. Now, the third point, second judge's case. Second judge's case. In bracket, you can write the formal name. Supreme Court Advocates on Record. Supreme Court Advocates on Record Association versus Union of India versus Union of India, 1993. So ये जो first judge's case हुआ था, it happened in, the verdict came in 1981 and it was challenged in 1987 and the verdict came in 1993. Okay. Right? The nine judge bench overruled its verdict in the SP Gupta case and established the mechanism of collegium system. Now, this particular case can be an example of what we called as judicial activism. Because if you look into the constitution, the word collegium is not mentioned anywhere. But yet it is establishing the collegium system. Judicial overreach, we cannot see. First of all, the difference between activism and overreach is not very clear. What is overreach from one perspective can be activism from the other. But why I stopped only at activism? Because judicial review is a term when the judiciary is respecting the text of the constitution as well as the idea given in the constitution. Judicial activism is when it is going beyond the text of the constitution, but it is not going beyond the idea of the constitution. Now, in this case, we see that definitely it is going beyond the text, because in the text of the constitution nowhere the word collegium has been mentioned. But it is not going beyond the idea of the constitution, because constitution talks about independent judiciary, and what we had seen previously, that the independence of judiciary was being played with, and therefore the idea was of the, at least what judiciary explained, the idea was that somehow we have to maintain the independence of judiciary from the control of executive. So therefore we cannot say that it is going beyond the idea of the constitution, because here also the mechanism is that collegium will suggest the names, the government can send back the name for reconsideration, and if the same name is again being sent, then ultimate decision to appoint that person as a judge is with the president only. So it's not that the judges are appointing judges by themselves, they are suggesting, and ultimate decision lies with the government. So it is following the same inter-institutional mechanism that the constitution was talking about. So that's why I would say that it definitely went beyond the text, but not beyond the idea given in the constitution. That's why we will avoid calling it judicial overreach. अब जुडिशियल ओवररीच क्या हो सकता है? एक रिसेंटली आपने जजमेंट पढ़ा होगा, द तमिलनाडु केस, कि तमिलनाडु केस में क्या हुआ कि 2 जजेस दे इंटरप्रेटेड आर्टिकल 200-201 और उन्होंने टाइम बाउंडेशन कर दिया. Now this was overreach, clear overreach, because when the constitution is not talking about time, how can you fix the time? And if at all it is to be fixed, it should at least be fixed by a 5-judge bench which interprets the constitution, and not by a 2-judge bench. And they also said that the 10 bills which were pending, they are deemed assent. Now there is no mechanism, wo text or idea ke beyond. So that is something that we will call as overreach. That's why we will consider this as activism. So this collegium was an example of judicial activism. If you see the sociological explanation of this, कि क्यों collegium लाया गया, then scholars believe that again we are in 1993. This is the time when the mandalization is happening. 1990 में मंडल कमीशन के implementation को announce कर दिया है VP सिंह ने, and the rest of the organs of the state, यदि बात करें legislature, so in legislature scheduled caste, scheduled tribes, they have got reservation under article 300 and 332, so 330 and 332. When we talk about executive, तो यहाँ पे भी the increase in the OBC representation is happening, legislature में भी और एग्जीक्यूटिव में. एग्जीक्यूटिव में क्यों हो रहा है? बिकॉज ऑफ रिजर्वेशन. लेजिस्लेचर क्यों हो रहा है? बिकॉज द आउटकम ऑफ ग्रीन रिवोल्यूशन हैज रिजल्टेड इनटू द स्ट्रेंथनिंग ऑफ बैकवर्ड क्लास लीडर्स. एंड इट इज सेड दैट जुडिशरी मेड एन एफर्ट थ्रू द कोलिजियम सिस्टम टू सेव द हायर जुडिशरी, एटलीस्ट लोअर जुडिशरी में रिजर्वेशन है, to save the higher judiciary, that is High Court and Supreme Court, from the larger mandalization which was happening. It was an effort to save that. In fact, इससे पहले there were law ministers from the backward classes communities, and it was said that in the matters of appointment, the backward classes were being preferred over. Again, objective truth नहीं हो सकता, it was a narrative, it was one of the criticism. And therefore judiciary is making this last attempt, this attempt to save itself from larger mandalization which is there, which is happening in legislature and executive. And therefore political social reasons were there why the collegium system came into the existence. ठीक, इसको लिखेंगे, राइट? क्या लास्ट लाइन क्या लिखा? Collegium system, right? इसमें लिखेंगे द रिकमेंडेशन ऑफ द कोलिजियम, the recommendation of the collegium was binding on the government, was binding on the government. That is, consultation means concurrence. Consultation means concurrence. The collegium had 3 members in bracket, right? Chief Justice of India plus 2 senior most members. इसमें लिखेंगे, right? In the appointment of CJI, in the appointment of CJI, the seniority norm was accepted. The seniority norm was accepted. जो सबसे सीनियर मोस्ट जज होंगे, सिंपली ही विल बी द चीफ जस्टिस ऑफ इंडिया until unless की कुछ मेडिकल प्रॉब्लम हो या फिर he himself is denying to. Now the fourth point, third judge's case. Collegium consists of, Supreme Court Collegium consists of CJI and 4 senior most judge, ठीक है? And there's a condition that next Chief Justice of India should be the member of the Collegium. हाँ, Collegium का next जो Chief Justice बनने वाला है, क्योंकि जरूरी है ना, अगला Chief Justice वही होगा, तो he should be in the decision making कि कौन कौन judges होने वाले हैं. So sometimes what happen is that the 4 senior most judges, वो इस तरीके से होता है that they are supposed to retire before the Chief Justice is retiring, and therefore the 6th member next CJI is added. इन 4 में से एक जैसे ही रिटायर करेंगे तब तो ऑटोमेटिकली ये 6 मेंबर से 5 मेंबर बॉडी बन जाता है. हाँ, ही विल बी, नहीं उनका नाम तो वो तो ऑटोमेटिकली बनेंगे, वो तो उनका नाम थोड़ी जाना है. यहाँ पे तो बात अपॉइंटमेंट, जो कोलिजियम है, कोलिजियम किस चीज के लिए? फॉर अपॉइंटिंग सुप्रीम कोर्ट जजेस एंड हाई कोर्ट जजेस के लिए होता है, ठीक है. सीजीआई तो ऑटोमेटिकली बनेंगे ना, जो भी नेक्स्ट जो सबसे सीनियर मोस्ट रहेंगे वो 7 दिन के लिए क्यों ना, ऑटोमेटिकली विल बिकम, राइट. फोर्थ पॉइंट, थर्ड जजेस केस, राइट. ऑन अ प्रेसिडेंशियल रेफरेंस, on a presidential reference, a 9-judge bench, a 9-judge bench unanimously supported the idea of collegium system, which expanded to include the CJI and four senior most judges. the 4 senior most judges. इसमें एक लाइन और लिखेंगे, the court maintained that the consultation shall be binding on the president. Next point is right. 99th constitutional amendment. 99th constitutional amendment. ठीक है. So from 1950 to 1993, the appointment is under kind of government's control till the second judge's case. 1993 to 1998, it is in a way being controlled by the collegium system. ठीक है. In 1998, towards the end of 90s, the political development happened in such a manner that government got stabilized. आप politics को देखेंगे, so 1989 to 1999 is the phase when we are having unstable government at the union. In fact, इससे पहले आप देखोगे from 1950 till 1989 we have one party government, जो कि most of the time it was Congress. For 3 years it was Janata Party government, but वो one party government. It was not a coalition. But from 1989, the phase of coalition politics begins, and coalition politics shows that one party has not been able to gather so much of seats कि वो अकेले government बना दे, and it will be a weak government. खासकर वो coalitions जो 1989 से 1999 तक होते थे, because for the first time India is experimenting with the coalition politics. उससे पहले दिखा नहीं है. So आप देखेंगे कि 1989 one government is being formed, National Front government, VP Singh. Then again the Prime Minister is changing, Chandrasekhar is becoming the Prime Minister. Then again after the elections are happening, then PV Narasimha Rao is becoming the Prime Minister. He will complete his tenure. After that, you will see that BJP government would be formed for 13 days. After that, you will see that Deve Gowda will become Prime Minister. After that, I.K. Gujral will become Prime Minister. Again, Vajpayee will become Prime Minister. All this is happening. 10 साल की duration में ideally 2 Prime Ministers होने चाहिए. But here governments are falling. That means the political situation is not good. Fragmentation है काफी. And therefore, जुडिशरी इज इंटैक्ट. जुडिशरी ने 93 में भी कह दिया कि हम डिसाइड करेंगे कौन अपॉइंट होगा जज. 98 में भी कह दिया हम डिसाइड करेंगे. बट व्हेन अ प्रेसिडेंशियल रेफरेंस वाज मेड अंडर आर्टिकल 143, व्हेन द प्रेसिडेंट आस्क्ड दिस क्वेश्चन अगेन, वी कैन कनेक्ट इट टू सम इंटरनल पॉलिटिक्स. कि जैसे आप देखेंगे 99 से गवर्नमेंट विल बिकम स्टेबल. From 99, the NDA government will come to power and it will complete its tenure of 5 years in 2004. After that, again from 2004 to 2014, we have UPA government which will complete 2 tenures. And after 2014 till now, we are seeing that we are having the NDA government, a strong government again in power. अब डिफरेंस क्या है कि इससे पहले भी कोलिशन, ये भी कोलिशन गवर्नमेंट्स थे, ये भी कोलिशन गवर्नमेंट्स थे, बट दीज कोलिशन गवर्नमेंट्स आर क्वाइट स्टेबल. एंड व्हेनेवर गवर्नमेंट विल बी स्टेबल एंड स्ट्रांग, it will try to take back the power which it has lost. क्योंकि ultimately 93 से पहले जजेस के अपॉइंट करने का पावर तो गवर्नमेंट के पास ही था, isn't it, that they have lost. And therefore the first effort was made when the recommendations, एक कमिटी बनाई गई in the year 2000 when the constitution completed its 50 years. हमने कब कॉन्स्टिट्यूशन स्टार्ट किया? 1950 में. In the year 2000 the constitution completed its 50 years and a committee was set up. The name of the committee was National Committee for the Review of the Working of Constitution. It was set up under Justice Venkat Chellaiya. और जो इस कमिटी का ऑब्जेक्टिव था कि लुक इनटू द कॉन्स्टिट्यूशन एंड सजेस्ट टू अस कि इस कॉन्स्टिट्यूशन में कौन से बदलाव करने, क्योंकि 50 साल हो गए पूरे. एंड वी हैव सीन दैट नॉर्मली देयर इज अ स्टडी, एम्पिरिकल स्टडी ऑफ द कॉन्स्टिट्यूशन फ्रॉम 1789 टिल 2006, जिसमें यह बताया गया है कि आमतौर पे अक्रॉस द वर्ल्ड one constitution survives just for 17 years. उसके बाद उसमें कुछ बड़ा मेजर चेंज होता है या फिर पूरा कॉन्स्टिट्यूशन ही चेंज हो जाता है. But now the constitution has survived for 50 years and therefore there was a review, there was a demand for कि इसको रिव्यू किया जाए कि कुछ इसमें मेजर चेंजेस करने की जरूरत है या फिर it is okay. You can also connect it to the politics of the day. NDA government is in power, the BJP government is in power, it is a right wing government. और right wing का complaint शुरुआत से ये रहा है कि this constitution is a Congress constitution. And there have been various aspects of the constitution including secularism, including the federal model that they have not liked. And therefore, a committee was set up in the year 2000, the NCRWC, to review into the working of constitution. और इस कमिटी ने रिकमेंड किया, this committee NCRWC recommended that the judicial appointment method को थोड़ा चेंज करने की जरूरत है. And it said that from inter-institutional method जो चल रहा है, we need to switch to the जुडिशियल अपॉइंटमेंट कमीशन मेथड. इसमें स्विच करने की जरूरत है. अभी तक चल रहा था कि प्रेसिडेंट विल अपॉइंट आफ्टर कंसल्टेशन बाय द जजेस ऑफ सुप्रीम कोर्ट एंड हाई कोर्ट्स, इंटर इंस्टीट्यूशनल मेथड. इसने कहा कि लेट अस स्विच टू द जुडिशियल अपॉइंटमेंट कमीशन और इन्होंने सजेस्ट किया दैट दिस जुडिशियल अपॉइंटमेंट कमीशन शुड हैव 5 members. 3 will be the judges. 3 जजेस में आपके आ जाएंगे एक चीफ जस्टिस, 2 सीनियर मोस्ट जजेस, 1 member फ्रॉम द सिविल सोसाइटी, हमारे और आपके जैसे लोग, ठीक है, एंड 1 विल बी द लॉ मिनिस्टर. 5 लोगों की कमेटी बनाई जाए. ये कमेटी तय करे कि कौन बनने वाला है जज सुप्रीम कोर्ट का और हाई कोर्ट का. जुडिशियल अपॉइंटमेंट सिस्टम की तरफ बढ़ते. एंड इन ऑर्डर टू ब्रिंग दिस, गवर्नमेंट ने एक अमेंडमेंट बिल भी लेके आए. दे प्रपोज्ड अमेंडमेंट बिल टू एस्टैब्लिश द जुडिशियल अपॉइंटमेंट कमीशन. बट व्हाट हैपेंड दैट इन 2004 द इंडिया गवर्नमेंट लॉस्ट, इजंट इट, एंड यूपीए गवर्नमेंट ने इस दिशा में कोई कदम नहीं बढ़ाया. दे वर सेटिस्फाइड विथ द इंटर इंस्टीट्यूशनल अप्रोच जो चल रहा था, कोलिजियम सिस्टम, दे वर ओके विथ. But in 2014, when again NDA government will come to power, 2014, and this time they are coming with good majority. उनकी खुद की सीटें बीजेपी की 282 थी, प्लस बाकी कोलिशन मिला के आराम से 300 से ऊपर जा रहा था. ठीक, so it was a very comfortable coalition. ठीक है, and they brought to the table the agenda that they had left unfinished in 2004, Judicial Appointment Commission. And the government brought 99th Constitutional Amendment Act. इसको लाया गया. This act proposed that constitution में amendment किया जाए and there should be a body to be established, that is National Judicial Appointment Commission. National Judicial Appointment Commission. ये जो commission होगा, it will make appointments for the Supreme Court, it will make appointment for the High Court judges, and therefore Article 124 Clause 2 was suitably amended, क्योंकि 124 Clause 2 में ही बताया गया था that how Supreme Court judges are to be appointed, and for this Article 217 Clause 1 was to be amended, and a new article was added 124A जिसमें NJSC body को establish किया गया, एक constitutional body को establish किया गया. Problem ये हुई कि this body was slightly different from what NCRWC had suggested, और वो जो slight difference ये था that it was supposed to be a 6-member body in which there were 3 judges by same Chief Justice of India and 2 senior most judge, and there will be 2 members from civil society and 1 will be the law minister, Minister of Law and Justice, who will be the part of this body. और एक और इसमें provision दिया गया that out of these 6 members, any 2 members can exercise veto power. यानी 6 में से कोई भी 2 मेंबर कह देता है कि ये जज अपॉइंट नहीं होगा, then his name would be, यानी 2 मेंबर ये नहीं इंश्योर कर पाएंगे कि जज कौन बनेगा, बट इतना जरूर इंश्योर कर देंगे कि कौन जज नहीं बनेगा. नेगेटिव वोटिंग. नाउ if you look at the structure of this, it appears to be a fair structure. 6 member body है. It is having representation from judiciary, from civil society, from executive. And if you see, distribution is also fair. 3 लोगों को judiciary से लिया है, 3 को non judiciary से लिया है. So ये काफी बैलेंस लगता है, isn't it? But ये सुप्रीम कोर्ट को बैलेंस नहीं लगा. सुप्रीम कोर्ट को लगा कि नहीं, ये बैलेंस नहीं. And one fine day they declared that 99th constitutional amendment जो है वो invalid है. क्यों invalid है? Because it violates the basic structure. Remember, this is amendment, this is not law. तो अमेंडमेंट को हटाने के लिए एक ही टूल है जुडिशरी के पास, दैट इज बेसिक स्ट्रक्चर डॉक्ट्रिन. इट विल नॉट बी रिमूव्ड बाय आर्टिकल 30. नाउ बेसिक स्ट्रक्चर डॉक्ट्रिन वाज यूज्ड. Which basic structure? The court said that it is violating independence of judiciary. Independence of judiciary जो है वो एक basic structure है. It is violating the independence of judiciary. Now the question is कि how is it violating the independence of judiciary? क्योंकि 50% representation किसका है? Judges का. और बाकी 50% में ये ग्रुप्स है सिविल सोसाइटी एंड द एग्जीक्यूटिव. सो हाउ कैन यू से दैट इट इज नॉट वायलेटिंग? जजेस ने कहा इट इज वायलेटिंग द इंडिपेंडेंस ऑफ जुडिशरी बिकॉज it is not giving primacy of judges in the appointment process. It is not giving primacy of judges in the appointment process. जो पहले Judicial Appointment Commission which NCRWC had suggested, it had 5 members जिसमें से 3 members judges थे. That means 60% vote share उनका है. In this 6 members 3 judges, that means 50% vote share. So it is definitely giving equality with the non-judicial members, और ऐसे individual देखेंगे तो भाई they have more, but it is not giving primacy. And therefore they said that only when the primacy of judges in the appointment process is there, then only independence of judiciary can be maintain. इसके बिना इंडिपेंडेंस ऑफ जुडिशरी मेंटेन हो ही नहीं सकती. And therefore they declared the 99th constitutional amendment as constitutionally invalid. मतलब गवर्नमेंट वही उसी को ये कर देती है. ये सेइंग कि फिर हाँ, तो ये सेइंग कि गवर्नमेंट ने वो 5 मेंबर वाले को क्यों नहीं मतलब क्यों नहीं इम्प्लीमेंट किया, क्योंकि गवर्नमेंट का भी तो कुछ एजेंडा होगा. ऐसा थोड़ी है कि गवर्नमेंट इतनी आसान है कि विच दिस वन. ठीक है, तो इट विल नॉट रिजल्ट इन अ डेडलॉक इन एवरी केस. नो, इट विल नॉट रिजल्ट इन टू डेडलॉक इन एवरी केस. वैसे देखा जाए तो फिर डेडलॉक में तो बहुत सारे केसेस में हो सकता है, बट सी आइडियली नहीं, why would it make it ineffective? The law minister and one of the judges gave us veto. So what they'll do, they'll veto against the candidate of the other party. Candidate of other party? Candidate of the other party is the non-judiciary member. And if the judges have the veto, they will not support the non-judiciary nominated person. And if the nomination has the veto, he may not support the judiciary appointed person. नहीं, but see, वीटो वाज अ प्रॉब्लम, जुडिशरी एक्सेप्टेड, लेकिन इससे डेडलॉक तो नहीं होगा. क्यों होगा डेडलॉक? एंड it will create a deadlock was not the reason Supreme Court declared that it is constitutionally invalid. Supreme Court के जो reasons दिए थे Supreme Court ने, Supreme Court very clearly said, first reason तो ये था कि primacy of the judges in the appointment process is not maintained, which is a part of the independence of judiciary, which is basic structure. हाँ, इसीलिए तो क्रिटिसाइज होता है ये थोड़ा वेग लगता है, इसीलिए this judgment has been criticized as tyranny of unelected. कि कुछ judges, because this 99th amendment was passed unanimously by the parliament, सभी ने support किया था. Half of the states had supported this, क्योंकि ये federal change है. ठीक है, हाई कोर्ट एंड सुप्रीम कोर्ट के जजेस के अपॉइंटमेंट की बात हो रही है, तो हाफ ऑफ द स्टेट्स हैड सपोर्टेड इट एंड द 5 जज बेंचेस डिक्लेयरिंग इट एज इनवैलिड. ये तो एक क्राइटेरिया था. द सेकेंड क्राइटेरिया दैट सुप्रीम कोर्ट सेड दैट दीज, ये जो वीटो पावर दिया गया है, इससे क्या हो सकता है, देयर कैन बी अ सिचुएशन व्हेन 2 सिविल सोसाइटी मेंबर्स विल एक्सरसाइज दिस वीटो. एक सिचुएशन ये हो सकता है कि the judges are saying that appoint this person, judges are saying appoint this person, and 2 members of the civil society, they would say don't appoint this person. इसमें क्या हुआ, country's top 3 judges, their decision is being negated by 2 members of the civil society. कोर्ट का ये कहना था कि it goes against the dignity of the Supreme Court. That top 3 judges, they are saying that appoint this person, और 2 सिविल सोसाइटी के लोग आके बोल दे रहे हैं डोंट अपॉइंटेड, और जजेस के डिसीजन को हटा दिया जाए. सो द सुप्रीम कोर्ट सेड दैट इट इज गोइंग अगेंस्ट द डिग्निटी ऑफ द सुप्रीम कोर्ट. कोई भी वीटो कर सकता है, और वीटो कर, देखो ये जो जजमेंट है, इट रिमेन्स वन ऑफ द मोस्ट क्रिटिसाइज्ड, क्योंकि जो आर्ग्यूमेंट्स इसमें जजेस ने यूज किए, आर्ग्यूमेंट्स ये भी दिया गया कि यू हैव गिवन वीटो पावर टू द इवन मेंबर्स ऑफ सिविल सोसाइटी, एंड दे सेड दैट सिविल सोसाइटी इन इंडिया इज नॉट दैट डेवलप्ड. ठीक है, कि वो सीनियर मोस्ट जजेस के डिसीजन को निगेट आउट कर दे, isn't it? So again it remains one of the criticized judgments. इसके बाद in fact there's one scholar, Faizan Mustafa, he writes very often on constitutional matters. He was vice chancellor of the National School of Law. He normally appreciates Supreme Court, but after this he also criticized the Supreme Court. He said that the 99th amendment should not have been declared invalid completely. आप इसको read down कर देते, Reading down means that you should interpret it in such a manner that the meaning, this 99th amendment would survive, but जो है उसको आप थोड़ा सा चेंज करें, जो भी प्रॉब्लम है. आपने पूरा का पूरा अमेंडमेंट बोल दिया कि इट इज null and so this remains one of the most criticized judgments of the Supreme Court. If you look into the politics of it, the power game is there. कि Supreme Court देख रहा है कि the court, the executive is trying to make its inroads into this. And एक argument ये भी था कि these two civil society members they may go with the law minister. लेकिन उससे भी ऐसा तो नहीं है कि ना कि वो अपॉइंट कर पाएंगे. इफ आउट ऑफ 6 मेंबर 3 आर जजेस, एक तो क्लियर है कि नोबडी कैन बी अपॉइंटेड विदाउट द अप्रूवल ऑफ जज, बिकॉज यू रिक्वायर 4:2. तो इतना तो क्लियर है कि विदाउट द अप्रूवल ऑफ अ जज नोबडी कैन बी अपॉइंटेड. एज फार एज वीटो पावर इज कंसर्न्ड, तो यदि वो किसी 2 मेंबर को मिला है तो वो तो आपको भी मिला है, आप भी उसको क्या कर सकते हैं, आप उसको वोट आउट कर सकते हैं, वीटो कर सकते हैं. बट अगेन हियर द एक्सप्लेनेशन इज दैट इट वाज इट कैन बी कंसिडर्ड एज वन ऑफ द जजमेंट्स wherein the judiciary did not want to give entry to the executive or civil society in the appointment system, because normally what happens is that whenever the inroads are made, then first equality, then you try to dominate over. And it was certainly one case wherein judiciary was trying to save its turf. It remains one of the most criticized judgments. They will be selected by a 3-member committee, including Prime Minister, including Leader of Opposition in Lok Sabha and the Chief Justice of India. यानी we don't have any reason to believe कि जो 2 सिविल सोसाइटी के मेंबर्स होंगे वो गवर्नमेंट के ही साइड के हों, क्योंकि अपॉइंटमेंट तो गवर्नमेंट, ऑपोजिशन और चीफ जस्टिस मिलके कर रहे हैं. So that's why he said that 99th amendment provided a fair provision for the appointment. But why it was negated? Of course, the judiciary said कि independence को violate कर रहा है. If you go into the real politics, it appears that maybe it was just a effort to save your turf. कि आप रिमूवल प्रोसेस आपके हाथ में है, अपॉइंटमेंट प्रोसेस आपके हाथ में नहीं जाने देंगे. सो इट हैज नॉट बीन. नाउ बार बार न्यूज आता है कि गवर्नमेंट इज थिंकिंग, रिकंसिडरिंग कि फिर से जुडिशियल अपॉइंटमेंट कमीशन को लाया जाए इन अ डिफरेंट फॉर्मेट. एंड इन फैक्ट आफ्टर दैट गवर्नमेंट एंड जुडिशियरी दे हैव एंटर्ड इनटू अ टसल. अभी क्या होता है कि जुडिशियरी कोलिजियम 10 नाम देती है गवर्नमेंट को, गवर्नमेंट उसमें से 5 नाम 4 नाम जो कि विच दे फील कंफर्टेबल उनको अपॉइंट करते हैं, रेस्ट दे डोंट अपॉइंट, बिकॉज देयर इज अ मैकेनिज्म कि इफ कोलिजियम इज suggesting any name to the president, when I'm saying it is the government, then they can send that name back for reconsideration once, एक बार भेजा जा सकता है. But once that reconsidered name goes, then president will have to appoint that person as the judge. But the problem is that no time frame has been mentioned. So names उनको वही रख दिया जाता है, and only when मतलब it is a kind of pocket veto that the government exercises. So and because of this, who ultimately suffers? People suffer. Because already if there is such a pendency of cases, 80,000 cases pending है सुप्रीम कोर्ट में, and उसमें भी यदि वैकेंसीज रहती हैं सुप्रीम कोर्ट और हाई कोर्ट, then ultimately it is the people of India who suffer. But somehow you'll find that already this particular case is called as the 4th judge's case, and it is believed कि हो सकता है कि हमें 5th judge's case भी देखने को मिल जाए, क्योंकि गवर्नमेंट फिर से अमेंडमेंट लाएगी ही लाएगी, and the judiciary will again react. ठीक है, so there's nobody can deny कि we will not have a 5th judge's case. There can be a probability of a 5th judge's case. ठीक है. नहीं, अभी वो है ही ना, मैंने बताया कि इसको हटा दिया गया था, इसको नल एंड वॉइड कर दिया गया था. नहीं ऐसा नहीं है, वो तो कॉलेजियम डिसाइड करती है, कॉलेजियम डिसाइड करती है। नहीं, अब व्हाट आर द पैरामीटर्स दैट कॉलेजियम कंसीडर्स, इसका बहुत डॉक्यूमेंटेड नहीं है, अभी हम देखेंगे कॉलेजियम के एनालिसिस। ठीक है, चलो आगे लिखे। राइट, अभी क्या लिखा आपने? 99 कॉन्स्टिट्यूशनल। ठीक है, राइट। आर्टिकल 124 क्लॉज 2 and 124 clause 2 and article 217 clause 1 were amended in 2014 right. The NJAC, National Judicial Appointment Commission, National Judicial Appointment Commission was established having following members, अब ब्रैकेट में लिख दो आर्टिकल 124 कैपिटल ए, इट वाज अंडर NJAC was established under 124 कैपिटल, इसका जो कॉम्पोजिशन वगैरह दिया गया। अब इसमें पॉइंट्स में लिख दो हु आर द मेंबर्स। राइट, 3 members from judiciary, including the Chief Justice of India and the 2 senior most judges, Second point, the Union Minister of Law and Justice, Next, two eminent persons from civil society, to be nominated by a committee consisting of dash देखिए लिखेंगे Chief Justice of India, comma, the Prime Minister and the leader of opposition in Lok Sabha. ठीक, अब इसमें से था कि जो 2 मेंबर्स होंगे उसमें से एक मेंबर या तो SC ST OBC माइनॉरिटी या फिर वुमेन से होगा, इसको भी लिख देते हैं। राइट, वन ऑफ द मेंबर, हाँ इसी में जो 2 सिविल सोसाइटी के मेंबर्स है ना उसमें से एक मेंबर, वन ऑफ द मेंबर्स would be nominated from SC/ST OBC, minority, or women. Write a paragraph. Any two members could veto a candidate from being appointed. Now write the next point. आपने 99th constitutional amendment लिखा, उसके बाद का next point, right? I think it's the fifth point. Sixth point, right? Sixth point, right? Fourth judge's case. 2015. Fourth judge's case 2015. स्पेसिफिक रीजन है ना, स्पेसिफिक रीजन है कि सिविल सोसाइटी देखो किसी भी प्लूरल डेमोक्रेसी में, या तो एक तो डेमोक्रेसी का एक मतलब हो कि ओनली दोज हु आर इन पावर होल्डिंग पोजीशन वही डिसाइड करे, बट गुड पॉलिसी मेकिंग हैपन ओनली व्हेन यू इन्वॉल्व सिविल सोसाइटी. अदरवाइज क्या आप देखेंगे कि कोई भी ड्राफ्ट आता है तो गवर्नमेंट क्या करती है कि उस ड्राफ्ट को अपने वेबसाइट पे डालती है एंड इट वांट्स द सिविल सोसाइटी टू गिव इट्स ओपिनियन ऑन दैट, है ना. इससे क्या होता है कि द लॉ और द एक्शन इज मोर लेजिटिमाइज्ड, क्योंकि अल्टीमेटली लोगों को ही एक्सेप्ट करना है. यदि ये काम फार्म लॉ के साथ हुआ होता, द 3 फार्म लॉज, तो कि पहले आप उसको डालो वेबसाइट पे एंड यू आस्क द फार्मर्स ऑर्गेनाइजेशन की सजेस्ट कीजिए, सिविल सोसाइटी को इन्वॉल्व करो, देन दैट प्रोटेस्ट विच हैपेंड वो नहीं होता. सो ऑलवेज इट इज रिकमेंडेड कि डेमोक्रेसी का मतलब ये नहीं कि बस आप वोटिंग कराएंगे. डेमोक्रेसी आइडली ऑल्सो मीन्स दैट व्हेन यू आर एट द स्टेज ऑफ लॉ मेकिंग वहां पे भी आप लोगों से कंसल्ट करें, ठीक है. सो हियर ऑल्सो वी आर टेकिंग एन इंपॉर्टेंट डिसीजन कि हु विल बी द जज इन सुप्रीम कोर्ट और हाई कोर्ट, एंड देयरफॉर ये एक्सपेक्टेड होता है कि कोई भी मेच्योर डेमोक्रेटिक सोसाइटी जो है वो सिविल सोसाइटी से कंसल्ट करे. दिस इज द रीजन. इनफैक्ट जजेस के अपॉइंटमेंट में कहा जाता है कि कोई भी प्रोसेस तभी काम करेगा व्हेन इट विल हैव रिप्रेजेंटेशन फ्रॉम द एडवोकेट्स, फ्रॉम द जजेस, फ्रॉम लेजिस्लेचर, एग्जीक्यूटिव एज वेल एज द सिविल सोसाइटी. जब तक ये 5 पिलर्स नहीं साथ में रहेंगे तब तक वो एक इंक्लूसिव मैकेनिज्म नहीं होगा. आउट ऑफ 6 इफ यू आर कीपिंग 1/3 टू सिविल सोसाइटी, वो बड़ा स्टेप है. मतलब 2 ही नहीं है ना, तुम देखो ना कि 6 मेंबर में से 2 है, सो यू आर गिविंग 33% रिप्रेजेंटेशन टू द सिविल सोसाइटी, ठीक है. इनफैक्ट एग्जीक्यूटिव का रिप्रेजेंटेशन भी उससे कम है. तो इट्स नॉट जस्ट 2 मेंबर्स, इट इज मतलब मेंबर्स वो फिक्स नहीं होंगे, वो चेंज ऑफ कोर्स होते रहेंगे, बट यू आर गिविंग 33% रिप्रेजेंटेशन टू द सिविल सोसाइटी फॉर द फर्स्ट टाइम. पहली बार इंक्लूड किया तो एक बड़ा स्टेप था. ठीक, ऐसा कोई जरूरी नहीं. एमिनेंट पर्सन मतलब होता है कि बेसिकली हु आर काइंड ऑफ अचीवर्स इन देयर फील्ड, कि किसी को लॉ की जानकारी हो, जैसे कि फाइनेंस कमीशन में डिफरेंट सेक्टर्स के जो एमिनेंट पर्सन है उनको लिया जाता है, ठीक है. बहुत सारे ऐसे होते हैं, कोई भी यदि अवार्ड गवर्नमेंट का देना होता है तो सोसाइटी के एमिनेंट, जैसे राज्यसभा में भी हमने देखा है कि राज्यसभा में नॉमिनेशन जो होता है ना फ्रॉम द फील्ड ऑफ साइंस, फ्रॉम आर्ट्स एंड ऑल, तो दे आर द एमिनेंट पर्सन. तो कोई जरूरी नहीं है कि दे विल फ्रॉम द एलीट ग्रुप. ऑफ कोर्स अब वहां पे 2 लोगों को ले रहे हैं तो पढ़े लिखे लोग को ही लेंगे ना, ऐसा थोड़ी है कि हाँ एमिनेंट का पर्सन का मतलब वो एलीट नॉन एलीट दोनों हो सकता है. चलो राइट. 4th जजेस केस क्या लिखा है इसमें? बस 4 जजेस 2000, राइट. A 5-judge bench declared the 99th amendment constitutionally invalid for violating the basic structure which included the independence of the judiciary and its primacy in the appointment process. ठीक है. Now 5 judge bench, फैसला 4:1 से आया था. One judge who was in favor of the NJAC was Justice Chelameshwar. तो यदि आप जस्टिस चेलमेश्वर का हिस्ट्री देखेंगे, देन इफ यू रिमेंबर, आज से करीब 8 साल पहले एक 4 जजेस ने प्रेस कॉन्फ्रेंस किया था अगेंस्ट द वे द सुप्रीम कोर्ट इज ऑपरेटिंग, अगेंस्ट द वे चीफ जस्टिस इज ऑपरेटिंग. ही वाज वन ऑफ द जजेस. Justice Chelameshwar, he has often questioned the legitimacy of the collegium system. Justice Chelameshwar का ये कहना था कि collegium system is as transparent as a black hole, कि जिस तरीके से black hole से कोई information बाहर नहीं आती, वैसे collegium system में what is happening वो पता नहीं चलता. In fact, अभी हम देखेंगे problem with the collegium system, that एनजीएसी को तो आपने इश्यूज गिना दिए कि एनजीएसी में क्या प्रॉब्लम थे, आपने डिक्लेयर कर दिया इट इज इनवैलिड. बट इफ यू लुक एट द वर्किंग ऑफ द कोलिजियम सिस्टम, इट इज ऑल्सो नॉट अ परफेक्ट मैकेनिज्म ऑफ जुडिशियल अपॉइंटमेंट्स बिकॉज इट्स इंटरनल डिलिबरेशंस आर नॉट ओपन. इनफैक्ट आप आरटीआई लगाएंगे, इट इज एग्जेम्प्टेड. आरटीआई एक्ट में सेक्शन 8 है, उसमें लिस्ट ऑफ एग्जेम्पशंस दे रखा है. सो हियर द इंटरनल डिलिबरेशन हैज बीन एग्जेम्प्टेड फ्रॉम बीइंग डिस्क्लोज थ्रू आरटीआई, और यदि ये डिस्क्लोज कोई करता है तो उस पर कंटेम्प्ट ऑफ कोर्ट लगता है. सो यू डोंट नो दैट व्हाट डिलिबरेशन इज हैपनिंग. एंड द वे, if you see, look at the profile of the Supreme Court judges, High Court judges, particularly Supreme Court judges, you'll find that most of them, they had some kind of family connections. So it has emerged as the elite men group, ki father or grandfather somebody was the chief justice or judge, and then that particular group, there's a domination of the upper caste, upper class group in the Supreme Court. The distribution or inclusiveness in terms of gender equality, we have not seen till now even a single Chief Justice of India from the women community. So it may not be just a coincidence that why only people from the elite group are coming to the Supreme Court and High Courts. In fact, if you qualify UPSC at a young age, मान लेके चलिए कि आप 25 से पहले 22, 23, 25 तक क्वालिफाई कर रहे हैं, देन 90% गारंटी है कि आप सेक्रेटरी लेवल तक पहुंचेंगे. 22 में आप क्वालिफाई कर जा रहे हैं, मतलब दैट मींस जस्ट फर्स्ट अटेम्प्ट में, देन देयर आर हाई चांसेस दैट यू विल बिकम द कैबिनेट सेक्रेटरी और चीफ सेक्रेटरी ऑफ द स्टेट टू 100%. बट इफ यू एंटर इनटू द जुडिशियल सर्विसेज वेयर यू एंटर थ्रू ओपन कॉम्पिटिशन, स्टेट पीएससीज जुडिशियल सर्विसेज कराती हैं, there is no guarantee, forget about guarantee, probability बहुत कम है कि आप हाई कोर्ट से या फिर सुप्रीम कोर्ट तक पहुंचेंगे. इन हाई कोर्ट जो है या फिर इन सुप्रीम कोर्ट, you'll find that those people are coming who are actually the practicing lawyers. ठीक है, क्योंकि जब अपॉइंटमेंट में की बात करें ना, तो अदर देन द क्वालिफिकेशन, कितने साल आपको हाई कोर्ट में होना चाहिए, इतने साल टोटल, there is a criteria that you should be an eminent jurist in the opinion of the president. Now this is an open category and you will see that the most of the judges who are entering, जो सुप्रीम कोर्ट तक पहुंच रहे हैं, बहुत रेयर ही आप देखेंगे कि जो कि जुडिशियल स्टेट जुडिशियल सर्विस से प्रमोट होके ऊपर तक पहुंचा है, राइट? सो व्हेन यू कंपेयर, मतलब आस्क्ड टू एन एस्पिरेंट हु इज गिविंग जुडिशियल सर्विसेज एंड यू कंपेयर, यहाँ पे देयर इज अ फिक्स्ड, आपको पता है कि इफ समबडी पीपल लाइक अजीत दोवाल दे आर एंटरिंग, तो ऐसा कोई जरूरी नहीं है कि यू शुड हैव दैट काइंड ऑफ पेडिग्री. So this composition raises a question that why only the elitist they are reaching to the Supreme. And एक जो सबसे और भी बड़ी प्रॉब्लम है कोलिजियम के साथ कि let us say the collegium is suggesting the name. इसमें से 5 लोगों ने 5 names they suggested. You will not come to know about them until unless जब उनका decision आ जाए. Ideally in other countries what happens is कि जो judicial appointment mechanism होता है कि the judicial appointment commission will say कि we are considering the name of these 10 people. Now if I have a problem against any of them, मुझे कुछ ऐसा information पता है जो मुझे बताना चाहिए, I can reach out and हो सकता है उसका नाम हटा दिया जाए. But here only when the collegium is giving out these 5 names, ये judge बनेंगे, then we come to know that this person will be the next high court judge or the Supreme Court judge. And because of this there have been certain embarrassment at times. 2-3 साल पहले एक जस्टिस विक्टोरिया of Madras High Court, she was nominated, she was by collegium ki that she will be the judge in the High Court, Madras High Court. और जब नाम आया तो फिर पता लगा that she had been involved in hate speeches against the minority community. And then people reached out and collegium maybe it was not aware of any such thing. So only when you are getting the name आप उसको challenge कर सकते हैं. और challenge का भी mechanism क्या है, that you are going to, if you find that ये decision जो ठीक नहीं है, आप challenge कर सकते हैं बिल्कुल, but this challenge will be before a bench that will be constituted by Supreme Court. कुछ उसमें judges रहेंगे. Now this bench which is going to review the decision of collegium is also constituted by the Chief Justice of India. और collegium का head कौन है? Chief Justice of India. At least member तो है ना उसमें, is the senior most member. Now how can the Chief Justice of India जिसका की decision है ये names, he will be the same person who will appoint a bench जो कि उसको रिव्यू करेगा. इट गोज अगेंस्ट द नेचुरल जस्टिस. ये तो कन्फ्लिक्ट, ये तो मतलब बीइंग जज इन योर ओन केस वाली बात आ गई कि मैंने ही डिसीजन लिया और मैं अपने कुछ, देखो सुप्रीम कोर्ट के 5 सीनियर मोस्ट जजेस तो उसमें बैठे हैं, तो यहां जो बैठे होंगे उससे जूनियर ही होंगे ना. अपने होशो हवास में इनके खिलाफ तो वो जाएंगे नहीं, उनको भी तो आगे बढ़ना है ना कुछ, isn't it? So basically it becomes a conflict of interest. एंड मोस्ट ऑफ द टाइम यदि कोलिजियम सिस्टम के रेयरली, पता नहीं यदि गया भी है कोई ऐसा करने, तो मोस्ट प्रोबेबली दे विल से नो टू दैट. सो दैट्स व्हाई कोलिजियम सिस्टम के साथ प्रॉब्लम तो है. दैट मीन्स जो जस्टिस चेलमेश्वर की मैं बात कर रहा हूँ, ही सेड दैट आई विल पार्टिसिपेट इन द कोलिजियम मीटिंग ओनली व्हेन यू विल पब्लिश व्हाट ऑल deliberations happened in the meeting. It will not be just a closed door meeting and then लोगों को पता होना चाहिए कि ये सारी चीजें इन नाम पे डिस्कशन हुआ, ये इनके मेरिट्स है, ये इनके डीमेरिट्स है, एंड देन वी आर कमिंग टू अ कंक्लूजन. इनफैक्ट वन ऑफ द डिफेंडर्स ऑफ द कोलिजियम सिस्टम वाज द फॉर्मर चीफ जस्टिस ऑफ इंडिया डी.वाई. चंद्रचूड़. ही सेज दैट व्हेन ही वुड बी आस्क्ड कि कोलिजियम सिस्टम पे भी तो बहुत आरोप लगते हैं कि कहीं ना कहीं नेपोटिज्म है, बायसनेस है. So he would defend saying that whenever collegium discusses, तो जिन judges के नाम को discuss कर रहे होते हैं, it looks into the merits. उनके पूरे career पे देखा जाता है कि what kind of cases they have decided and can we rely on him as a good judge or not. Intelligence reports are shared. कोई भी हाई कोर्ट जज बनता है, the intelligence reports are shared. IB shares the report that if there's anything which is doubtful about this particular case. And he says that the way selection of cricketers are supposed to be done by cricketers, मतलब क्रिकेट टीम आप सिलेक्शन कर रहे हैं तो वहां पे पॉलिटिकल साइंस प्रोफेसर को बिठा दीजिएगा तो थोड़ी नहीं वो अच्छा जज कर पाए. Similarly, what is wrong when judges, which is a professional work, are being appointed by judges because they best know ना. आप किसी पॉलिटिशियन को रखेंगे, हो सकता है उसको फर्स्ट शेड्यूल का मतलब ही नहीं पता, हो सकता है, isn't it? ऐसे पॉलिटिशियन हमारे देश में हुए कि एक मैं एग्जांपल जो नॉर्मली देता हूँ, बिहार के एक हमारे पॉलिटिशियन है तेज प्रताप यादव जी. उनसे एक रिपोर्टर ने पूछा कि आपको क्या लगता है कि भोजपुरी को 8th शेड्यूल में डाल देना चाहिए? तो उन्होंने कहा 8th शेड्यूल का, हम तो कह रहे हैं फर्स्ट शेड्यूल में डालिए. अब बताओ, लेट अस इमेजिन अ सिचुएशन, ही बिकम्स द लॉ मिनिस्टर और इंडिया में प्रोफाइल जो होता है वो नंबर ऑफ सीट्स के हिसाब से मिलता है. ऐसा नहीं है कि यू आर नोइंग, यू हैव द नॉलेज ऑफ लॉ इसलिए आपको लॉ मिनिस्टर बनेंगे, या फिर आपको रेलवे की नॉलेज है तो आप रेलवे मिनिस्टर बनेंगे. इट्स ऑल अबाउट आपके पार्टी के पास कितने सीट्स हैं. प्लस इनफैक्ट वन ऑफ द ग्रेटेस्ट लॉयर्स राम जेठमलानी, ही ऑल्सो सपोर्टेड कोलिजियम. ही सेड कि मोस्ट ऑफ द केसेस जो हम देखते हैं, आप देखेंगे दिस वर्सेस यूनियन ऑफ इंडिया, दिस वर्सेस यूनियन ऑफ इंडिया. दैट मीन्स गवर्नमेंट इज अ पार्टी, is a litigant. In 80% of the cases, government is the litigant. So how can you include a litigant in the appointment mechanism? That is the law minister. So again, there are arguments in favor, against, but yes, the conclusion is that collegium system at least needs more transparency. That what is the mechanism, क्या merit वो consider कर रहे हैं, there should be a transparency. Because if judiciary is asking for accountability of others, then it should also hold itself accountable in the eyes of the people. कि जो लोग अभी पार्लियामेंट में पहुंचे हैं, ठीक है, मान के चलो हम कहते हैं 46% have criminal cases recorded against them, but ultimately we have selected them. They have the legitimacy that they have won through elections, but such kind of legitimacy is not claimed by the Supreme Court judges. They may be completely untouched with the ground reality. So in that case, at least transparency should be one of the mechanism that should be followed. और उसमें भी यदि कोई क्वेश्चन करने जाएगा, आप कंटेम्प्ट ऑफ कोर्ट लगा देंगे. तो जहां आपको क्वेश्चन किया जा सकता है, आप कंटेम्प्ट ऑफ कोर्ट लगा देंगे. So therefore, it is demanded that transparency is something that can be introduced in the appointment system. Forget about law. Government brought an amendment. What happened to the amendment? Invalid. Transparency, no? For example, they would bring a law, or let us say amendment ही मैं बोल रहा हूँ, in which they will say that each and every detail of the deliberation of the collegium will be published, for example. But this can be declared as invalid because judges will say that this, if everything is being published, we cannot we cannot discuss the merits and demerits of the judges. बहुत सारी, इनफैक्ट आप देखेंगे RTI में द नोटिंग्स, जो एक कोई फाइल आता है ना, कोई प्रोजेक्ट आने वाला होता है, तो ब्यूरोक्रेट्स एट डिफरेंट लेवल दे राइट अ साइड नोट कि व्हाट इज देयर ओपिनियन ऑन दैट. इफ यू फाइल RTI, आपको वो साइड नोट का इंफॉर्मेशन नहीं मिलेगा. It is exempted from the RTI. Why? Because if everything will go in the public, then deliberation cannot be proper. So if what you are suggesting, if it happens, I believe that it will be declared invalid on the similar ground that it is violating the independence of judges. Okay? Again?
Will this not ensure integrity in the institution of India?
But again, the thing is कि it is all about how judiciary is going to interpret. This was a very fair combination, but judiciary को लगा कि it is violating the basic structure. Again, all these things we cannot say for sure, but most probably what 99th amendment has happened to 99th amendment, the same thing is going to happen to the same case, the laws also. ठीक है, चलो राइट इसको क्या लिखा अभी? फोर जजेस केस, उसमें क्या लिखा मैंने? अच्छा ठीक है, इसमें एक लाइन और लिख दो, राइट. द सुप्रीम कोर्ट, the Supreme Court also argued that the veto power will adversely impact the primacy of judiciary. Primacy of judiciary. The government itself is a litigant in most of the cases. Write a paragraph. Meanwhile, the collegium system has been criticized for lack of transparency, right. Its internal deliberations cannot be revealed through RTI, the appeal against the decision of the collegium comes before the Supreme Court itself, and therefore it goes against the principle of natural justice, Okay. Now give a subheading: removal of the judges. Removal of the judges. Now a judge can exit the office in 3 ways. Okay, either he will retire when he completes the age of retirement 65, either he will retire. Okay, in fact the difference in the retirement age 62 and 65, okay, people say that it has been kept so that the high court judges will have this hope till the last कि लास्ट के 3 साल सुप्रीम कोर्ट में भी बिताए जा सकते हैं. Then only you will listen to the seniors, no? In fact, one of the judges would say that a high court judge is always in pressure to be in good books of the supreme court judge, क्योंकि एक दिन वही डिसाइड करने वाला है कि आपको सुप्रीम कोर्ट आना है कि नहीं आना. ठीक है. So one method is that you will retire when you will complete your age. Second is that you may resign, and third is that you can be removed from the office. Okay. Now the interesting part is that अभी जो current Chief Justice of India है वो कौन सा 54th है कि 55th है? 53rd, 54th होंगे आई थिंक. ठीक है. If you look into the judges in US में केवल एक ही क्राइटेरिया है, इफ यू मेंटेन गुड बिहेवियर आप जज रहेंगे. वहां पे वंस यू बिकम अ जज आपका रिटायरमेंट का कोई फिक्स एज नहीं होता है, बस गुड बिहेवियर मेंटेन करके रखना. ठीक है. एंड दैट्स व्हाई यू विल सी दैट जजेस देयर, इनफैक्ट ये जो चीफ जस्टिस जॉन मार्शल थे, हिज टेन्योर वाज 34 years 152 days. 34 साल से ये चीफ जस्टिस ही रहे थे, चीफ जस्टिस रहे थे. जज की तो बात तो छोड़. सो बिकॉज देयर इज नो अपर लिमिट. इंडिया में जो चीफ जस्टिस जिन्होंने मैक्सिमम समय गुजारा है एज अ चीफ जस्टिस इज वाई चंद्रचूड़. ओके, he remained chief justice for 7 years 139 days. maximum इनका tenure. यूएस में मैक्सिमम कितना है? 34 years 152 days. यहाँ पे से 5 almost 5 times there, because there is no upper limit of कोई रिटायरिंग एज नहीं है. तो एक बार कोई चीफ जस्टिस बन गया तो फिर अब वो जब तक गाड़ी अपना नहीं हटाएगा बाकी वाले नहीं बनेंगे. ठीक है. और वो जब तक उसको लग रहा है कि दिमाग काम कर रहा है वो बने रहते. ठीक है. After him 4 years Bhuvneshwar Prasad Sinha and Ajit A.N. Ray. His tenure is 3rd. इनका एक कारण ये भी था, ये समय से पहले चीफ जस्टिस बन गए थे. मैंने बताया ना कि आफ्टर केशवानंद भारती केस the 3 judges were superseded to make Justice A.N. Ray as the next Chief Justice of India. नहीं चल रहा था ना तब. वो तो सेकेंड जजेस केस 1993 में कहा गया, वो एक कन्वेंशन फॉलो किया जा रहा था. ठीक है. इनफैक्ट नेहरू ऑल्सो ट्राइड टू मेक समबडी एल्स एज द चीफ जस्टिस ऑफ इंडिया, ब्रिंगिंग फ्रॉम आउटसाइड, जब केवल 7 जजेस हुआ करते थे. नहीं, मिनिस्ट्री ऑफ लॉ एंड जस्टिस जो है लिख के देगी प्रेसिडेंट को कि आप इनको एन रे को अगला चीफ जस्टिस ऑफ इंडिया का शपथ दिला दीजिए. दैट्स इट, फिनिश. ठीक है. अभी भी इट इज इन द मेमोरेंडम ऑफ प्रोसीजर, कोई लॉ नहीं है. अभी भी यदि इफ गवर्नमेंट वांट्स, प्रेसिडेंट वांट्स, वो किसी को चीफ जस्टिस बना सकते हैं. ठीक है. इट इज जस्ट अ काइंड ऑफ एग्जीक्यूटिव डिसीजन व्हिच हैज बीन टेकन. ठीक है. तो सिंस ही बिकेम द चीफ जस्टिस बिफोर टाइम, ठीक है, 3 जजेस से पहले वो बन गए एंड देयरफॉर टेन्योर. इनफैक्ट डी.वाई. चंद्रचूड़ आल्सो ही रिमेन चीफ जस्टिस ऑलमोस्ट फॉर 2 years. एंड दैट्स व्हाई मैंने बताया ना कि ये काफी समय तक थे. तो आप देखेंगे कि द नेक्स्ट जजेस दे वर नॉट एबल टू बिकम द जस्टिस. इनफैक्ट ऐसे भी जज रहे हैं जो कि 17 दिन के लिए चीफ जस्टिस ऑफ इंडिया बने थे, 17 days. बिकॉज सिंपल सा फॉर्मूला है, हूसोएवर इज द सीनियर मोस्ट, चाहे वो एक दिन के लिए क्यों ना बनना हो. ठीक है. वो घर भी नहीं शिफ्ट करता होगा अपना, कहाँ जाएंगे चीफ जस्टिस. यही ठीक, 17 दिन के लिए बनोगे. इनफैक्ट जो आई थिंक जस्टिस नागरत्ना, शी इज गोइंग टू बिकम द फर्स्ट वुमेन चीफ जस्टिस ऑफ इंडिया. उनका भी टेन्योर काफी कम ही रहेगा, बट नेवरदलेस आई थिंक इट विल बी लेस देन 6 months. देयर इज अ प्रपोजल कि चीफ जस्टिस ऑफ इंडिया उन्हीं को बनाया जाए हु कैन एटलीस्ट बी इन दैट ऑफिस फॉर मिनिमम 6 months, क्योंकि उससे कम में तो आप कुछ नहीं कर पाओगे। इनफैक्ट आप खुद को सीरियसली नहीं लोगे, क्योंकि जब आपको पता रहेगा कि 20 दिन बाद 1 महीने बाद चीफ, दूसरे आपको सीरियसली तो नहीं लेंगे, खुद भी आप अपने आप को सीरियसली नहीं लोगे, isn't it? So चीफ जस्टिस का एक ही प्रोसेस है, द सीनियर मोस्ट जज बिकम्स। नाउ हाउ द जज इज रिमूव्ड, अभी काफी न्यूज में चल रहा है ना, बिकॉज ऑफ जस्टिस वर्मा। जस्टिस वर्मा जो कि किस हाई कोर्ट के, इलाहाबाद में, दिल्ली हाई कोर्ट के थे, लेकिन उनको इलाहाबाद भेज दिया गया। इलाहाबाद वालों ने कहा कि ये क्या मतलब है, कोई भी खराब निकलता है हमारे यहाँ भेज देते हो, हैज इट बिकम अ डंपयार्ड ऑफ, क्या किसी को भी होता है वो तुरंत इलाहाबाद भेज देते, ठीक है। सो जस्टिस वर्मा के घर में अभी प्रोसेस अभी स्टार्ट नहीं हुआ वहां, और जस्टिस उनका नाम था, जस्टिस वर्मा के घर में पैसे मिले थे, ये तो स्टैब्लिश हो गया कि पैसे मिले थे, लेकिन ये नहीं स्टैब्लिश हुआ कि उन्हीं के पैसे हैं। तो ये लग रहा है कि जैसे कोई किसी का पैसा वहां आके रख देता हो, जैसे तुम ही अपना कुछ ले जाके कहीं रख देते हो, ऐसा होता है, क्योंकि हम तो 10 रुपया भी अपना याद रखते हैं कहाँ रखा गया है। अमीर आदमी ऐसे करते हैं, पैसा कहीं रखा होता है पता नहीं होता। एनीवे, नाउ व्हेन अ जज इज टू बी रिमूव्ड, सी ट्राई टू अंडरस्टैंड, प्रोसेस थोड़ा डिफिकल्ट दिया गया है। क्यों डिफिकल्ट दिया गया है? बिकॉज in most of the cases judges have to question government and therefore एक level it should be tough, so that ऐसा ना हो कि आप उधर केस पे डिसाइड करो, इधर आपका डिसीजन हो जाए। तो that's why थोड़ा सा टफ बनाया गया इसको। टफ क्या है? that when any सुप्रीम कोर्ट और हाई कोर्ट जज किसी को भी रिमूव करना होता है, then the process can start either in लोक सभा or it can start in Rajya Sabha. If it is to start in Lok Sabha, then it will be initiated by minimum 100 members signing that resolution कि हमें support करते हैं इनको हटाने का process. And if it is starting in Rajya Sabha, then minimum 50 MPs will sign on that petition. Then this will go to the respective presiding officers, speaker हो या फिर वाइस प्रेसिडेंट हो, उनके पास ये पिटीशन जाता है, एंड देन दे कैन डिसाइड दैट वेदर दे हैव टू प्रोसीड विथ दिस पर्टिकुलर प्रोसेस और दे हैव द डिस्क्रिप्शन। इफ दे आर डिसाइडिंग यस वी हैव टू प्रोसीड विथ दिस पर्टिकुलर प्रोसेस, इन दैट केस दे विल फॉर्म अ कमिटी। ये प्रोसेस कहीं एक जगह से हो रहा होगा, ठीक है। सो लेट अस से if it is happening in Lok Sabha, then he will form a 3-member committee having members from एक eminent person होगा, Supreme Court, High Court judge, and this 3-member committee will look into this charge that whether he is fit to be continue as a judge or not. That means constitutionally जो है he is fit or not. And after that whatever decision that particular report gives, this report will be discussed in the Lok Sabha. The Lok Sabha will have to pass it by special majority. Special majority means minimum half of the membership plus 2/3 of the present and voting. Once it is passed by the Lok Sabha, then it will come to Rajya Sabha. Rajya Sabha में भी वही होगा, the process of discussion, फिर से inquiry नहीं होगी, फिर the discussion and the voting will happen. Here also if the voting is happening by special majority, then after that this proposal will go to the President of India, and President of India will have to sign this particular thing, and then the judge will be removed. Interesting part is that till today not a single judge has been removed. कभी लोकसभा में स्टार्ट हुआ, राज्यसभा में प्रपोजल नहीं पास हुआ, okay, sometime the speaker did not agree to continue with that particular complaint. There has been times when one of the judges he resigned before he was removed, because it is far more honorable to be to resign rather than being the first judge to be removed, isn't it? और अभी हम देख रहे हैं कि जो जस्टिस वर्मा से रिलेटेड स्टार्टिंग में ही प्रॉब्लम हो गया, It has already seen one of the casualty, the vice president. ठीक है, अभी देखते हैं कि whether he will be removed or not, but it is a very difficult process to remove a judge. Again, why? Because you want to maintain the independence of judiciary, because removal is the one process through which the government can control the judiciary. This process को लिख देंगे, right? There's a law involved here, that is the Judicial Inquiries Act 1968. Same. It will be half of the membership plus 2/3 of the present and voting. Right. A Supreme Court or High Court judge, a Supreme Court or High Court judge can exit the office, through following ways. Points में लिखेंगे, first point. By retiring, second, by resigning, third, by being removed, write a paragraph. It must be noted, that in US, federal judges serve for life. Because Article 3 of the Federal Constitution declares that a judge shall hold office. हाँ भाई, Article 3 of the Federal Constitution declares that a judge shall hold office during good behavior. Next paragraph. In India, Parliament can remove a judge through following way. In bracket, right? Article 124 and Article 218. Article 124, particularly यदि लिखना है तो Article 24 clause 4 and 5. Article 124 clause 4 and 5. So Article 218 is talking about the removal of High Court judges. 124 clause 4 and 5 is talking about the removal of Supreme Court judges. The process is exactly same, but articles are different. ये प्रीलिम्स में ध्यान रखना, प्रोसेस एग्जैक्टली सेम है। क्यों? क्योंकि जब आप आर्टिकल 218 में जाएंगे, इट इज सेइंग दैट द प्रोविजन ऑफ क्लॉज 4 and 5 ऑफ 124 शैल अप्लाई इन केस ऑफ हाई कोर्ट्स ऑल्सो, यानी एग्जैक्टली प्रोसेस सेम हो। ठीक है, अब 4 and 5 में है क्या? इट सेज दैट ईच हाउस ऑफ द पार्लियामेंट शैल सपोर्ट बाय स्पेशल मेजॉरिटी, भाई मेजॉरिटी ऑफ द टोटल मेंबरशिप एंड 2/3 ऑफ प्रेजेंट एंड वोटिंग। ठीक है, क्राइटेरिया क्या है? प्रूव्ड मिसबिहेवियर और इनकैपेसिटी। अब ये थोड़ा सब्जेक्टिव क्राइटेरिया है, बट वो जो 3 member कमिटी बनेगी, दे विल स्टैब्लिश कि क्या प्रूव्ड मिसबिहेवियर और इनकैपेसिटी पे ये केस स्टैब्लिश हो पा रहा है कि नहीं हो पा रहा है, एंड आफ्टर दैट द पार्लियामेंट विल डिस्कस। ओके, पार्लियामेंट मे बाय लॉ, विच लॉ? द कॉन्स्टिट्यूशन सेज दैट पार्लियामेंट मे बाय लॉ प्रोवाइड कि इन दोनों क्राइटेरियाज पे जजेस को कैसे हटाया जाए। द पार्लियामेंट हैज ऑलरेडी मेड अ लॉ एंड द नेम ऑफ द लॉ इज जजेस इंक्वायरी एक्ट 1968। तो ये जो प्रोसेस मैंने बताया ना, क्योंकि कॉन्स्टिट्यूशन में तो लिखा नहीं है 150 कैसे जाएगा, दिस प्रोसेस इज मेंशन्ड इन द लॉ। ठीक है, दैट 100 जजेस, 100 members, 50 members, देन द स्पीकर, वाइस प्रेसिडेंट, ये सारी चीजें वहां पे मेंशन है। तो इसको पॉइंट्स में लिख देंगे, राइट। As per Judges Inquiry Act 1968, as per Judges Inquiry Act 1968, at least 100 members of Lok Sabha or at least 50 members of Rajya Sabha may give a signed notice to the presiding officer मतलब स्पीकर या फिर चेयरमैन, जो भी। सेकेंड पॉइंट, राइट, द प्रिसाइडिंग ऑफिसर may decide to either admit the motion or refuse to admit it. Refuse to admit it, मना भी कर सकता है। Next point. If the motion is admitted, the presiding officer will constitute a 3-member committee. 3-member committee having, इसको सब पॉइंट्स में लिख दो, a Supreme Court judge, next, Chief Justice of a High Court, third, a distinguished jurist, next, distinguished jurist. Next point, right, the committee will inquire to established misbehavior or incapacity. Misbehavior or incapacity. Next point. The motion for removal shall be adopted by each house of the parliament through special majority. Last point. The president shall remove the judge. एक लाइन लिख दो. It must be noted that not a single Supreme Court or High Court judge, has been removed so far. ठीक है, in the next class. Thank you. हाँ, ये स्पीकर या फिर चेयरमैन पे डिपेंड करेगा वो किसको सेलेक्ट करना है. ठीक है, थैंक यू.